Support is resumed. Please be seated. Justice Hennessy, I wanted to move on to our argument that economic rents are too hypothetical to form the basis of an award in this case. Economic rents is a theoretical concept that frankly is hard to understand for non-economists. On the one hand, we have Professor Stiglitz telling us it's simple and taking us through colorful bar graphs, making it look simple and obvious. But on the other hand, we had three other very well credentialed doctorates in Canadian public economics, not to mention Fred O'Riordan, who also has excellent credentials, telling us that the theory of economic rents is imperfect and it is unrealistic to use it here as the basis for the Crown's duty. Mr. Schachter criticized the Crown's experts, Professor Bodway, Smart, and Mintz. And I'm referring to those three in particular because they're the doctorates in Canadian public economics that I'm referring to. They're all very well credentialed. Despite the criticisms that Mr. Schachter had of their evidence, they all worked hard with very complex materials in an effort to assist the court. And they are all recognized experts in their field. Professors Mintz and Smart have both consulted for the World Bank and the IMF. In the case of Professor Smart, also consulting for the government of Australia and the European Commission. Professor Mintz has consulted for the OECD. Professor Bodway is a textbook author on public sector economics. He's taught around the world, including Spain, Finland, Japan, China, consulted again for the World Bank and the IMF, and he has written 3 books with Professor Stiglitz. So these are well-credentialed Canadian public economists. These experts, Professors Bodway, Smart, Mintz, and Mr. O'Riordan, explain resource rents to us this way. And I'm going to put their definitions up on the screen and read through them to ensure that we all understand what we're talking about. So Professors Smart and Bodway defined resource rents at paragraph 35 of their report, which was marked as Exhibit 62. They, of course, had a number of reports, and I'm referring to the one marked as Exhibit 62. At paragraph 35, they say, resource...
By chance, is this in your compendium?
I'm afraid to say, Justice Hennessy, we don't have a compendium for this argument, for the net Crown resource revenues argument. The compendia that you have from Canada are either relating to Crown allocation or specifically case law on the principles. Unfortunately, for the rest of our submissions, we don't actually have a compendium, partly because I've really designed these submissions to be responsive to my friends. So I regret that, but in each case, what I will do is emphasize where in the transcript, or sorry, where in the record, in the evidence you can find what I'm speaking of. So even if we don't have it to pull up on the screen or before you, I'll give you the references so they'll be in the transcript of the submissions. So we're starting at Exhibit 62, paragraph 35. Professors Smart and Bodway describe resource rents this way. Resource rents are the incomes that are properly attributed to the use of unprocessed natural resources in production processes. And I have to admit, it took me quite a long time to really understand what they're getting at. But having heard all of the evidence from this definition, I think it is fair to consider rents as the economic value of the raw, unprocessed natural resource itself. Once you take the price or total income, as Smart and Bodway would say, of the processed product and then back out or strip away the costs, such as specifically the labor, inputs like energy and capital, including profits for investors, these items of cost. And theoretically, what is left is the value of the raw, unprocessed resource itself. Although we note at paragraph 114 of our written submissions, to remember that the raw resource itself doesn't have monetary value until it is extracted and processed. So it's only once it's been extracted and processed that we can speak about the rents that arise from it or that can be attributed to it. So then I'd like to look at the definition that Professor Mintz and Mr. O'Riordan provide.
So you've given me the Smart and Bodway definition and then your version of it.
My understanding of what that means, yes.
Okay.
And I hope that's helpful. But Justice Hennessy, I find this interesting. If we in this room cannot all agree on what resource rents actually means, that's just further example why it's a completely unrealistic and impractical theory to be using.
Is that your premise? That we cannot all understand it?
No, it's not my premise. I'm trying to explain it using these definitions.
Yes.
Yes. So no, I think it can be understood, and certainly I'm trying to explain to the court how I understand it based on the evidence that we heard with reference to the specific definitions that the experts or some of the experts have used. My attempt here, Justice Hennessy, is to situate the court in really understanding what we're talking about when we talk about economic rents. But I do find it interesting that, you know, your question being, is this my definition of economic rents? Is this my understanding of economic rents? And what I find interesting in that is, I think it does reflect the fact that economic rents are difficult to understand, and it might be the case that not everybody understands them. Or certainly not everybody understands them the same way.
But I'm wondering why you're going through, you've just given me the Smart and Bodway definition, and then you were going to go to Mintz and O'Riordan.
That's right.
But you gave me then your version of one. Is your version of Smart and Bodway's going to be different from your version of Mintz and O'Riordan?
No, I don't think so.
Okay.
No, I just think it's just using language in a different way to try to express the same concept.
Okay.
Okay. For example, Smart and Bodway, when they say it's resource rents are the incomes, you know, I use the word in my rephrasing of it, the price, right? For example, and whereas they use the word unprocessed natural resource, I use the word raw. But I'm trying to convey the same idea. I'm not trying to describe it as something else. I'm just trying to assist, I'm hoping assist the court. So really, I'm not trying to say that the experts came up with different definitions. I'm just trying to make sure that the court is situated to what I submit the experts, how they have explained economic rents, because I think it'll help with understanding the rest of my argument. So, and I have not actually used the definition of economic rents from Professor Stiglitz's work. That's not out of any, you know, in fact, if perhaps at a break, I'll go and take a look and see exactly how they define it as well. I think all of the experts defined it slightly differently, but they're obviously all arriving at the same result. But I do want to look at the Mintz and O'Riordan definition, because again, I found their phrasing of it helpful. And this is at their report, which was marked as Exhibit 29. And it's paragraph 13 of their report. And they describe resource rents as follows. Resource rents are based on an economic concept the difference between revenues from the sale of natural resource products and the economic costs of producing them. That sounds very simple, but I think it requires a bit of explanation. When they talk about the difference between revenues from the sale of natural resource products, we have to keep in mind, they're not talking specifically about Crown revenues. They're talking about total revenues, or the terminology Professor Smart and Bodway used, which was the incomes. And when they talk about the sale of natural resource products, here they're referring to processed products. And when they talk about the economic costs of producing them, we've learned through testimony that they include labor inputs, which frankly I found a little confusing until one of the experts gave the example of energy as an input, and capital. So again, the definitions don't differ. They capture the same thing. It's just different ways of getting at it. And what I like about the Mintz and O'Riordan definition is it conceptualizes rents as the difference between the total revenue, not just collected by the Crown, and the cost of producing that revenue. And when you look at it that way, one can see rents as a type of profit.
Well, I don't want to say I like colorful charts, but wasn't that one of the colorful bar graphs from Professor Stiglitz that he went back to over and over again?
Yes, indeed it was. And helpfully, both Professor Stiglitz and Professor Mintz referred to rent as excess profit. They talked about normal profit. And I think Professor Mintz described this thoroughly in his testimony. Normal profit being, of course, investors need to make a profit. They need to make a profit that will provide them the return that they would have received if they'd invested their money elsewhere in a different project.
As I understood it, 1 penny more is the excess profit.
Under the theory of economic rents, yes, that's right.
And the 1 penny more would be is what keeps you in that location. You can make profits in Northern Ontario that are as good as better as you can make in Louisiana.
Well,
that's the anticipated or the regular or the ordinary or the profit.
What's interesting about that, Justice Hennessy, and I'm so glad you raised it, because it gets at this problem already about what constitutes an excess profit. And if that 1 penny more is part of the excess profit, but on the other hand, that 1 penny more is what is keeping you where you are, it's not really excess profit anymore. It's the return that you need in order to continue this economic activity. And I'm going to get into that. I think, for example, how do we determine what are excess profits? First of all, we have to consider, well, what is the price? First, you have to consider.
Why do we need to do any of this?
Because we need to understand why economic rents are not the appropriate measure here for the plaintiff's loss. And in order to do that, we need to understand what economic rents means. And we need to understand why all 4 of the economists that testified on behalf of Canada and Ontario testified that economic rents is not an appropriate measure here because the theory is too hypothetical, it's too impractical, it's imperfect and unrealistic. And that's why I'm going through this, is to explain the problems with it. And one of these problems is defining what is excess profit. And the experts for the Crown told us there were 2 main problems with this concept of excess profit. One is a problem in measurement. The other is a problem in collection. And I'm not going to spend too much time on this, Justice Hennessy. I understand you may not feel that you may wonder, why do we need to go through this? But I would like to go through the problems.
I don't mind going through Ontario or Canada's view of the theory, the concept. I thought you were going a bit deeper than that on something else, but no, I think it's important
Okay,
to hear you on this.
thank you. So I wanted to first deal with the measurement problem. How do you measure what is this excess profit? And I'm going to refer to rent as excess profit because frankly, that is the way that I find it most easy to understand, because I think we can understand the difference between the price and the cost to produce it. So first, in determining what is the excess profit, because again, we're getting at how do you measure the economic rent? How do you measure the excess profit? The first consideration is going to be the price. But how does one measure what is the right price? Well, usually because it's based on competition in the market. But we know that the market is not perfectly competitive. Our experts told us that. One of the problems with economic rents is that it assumes perfect competition. Then we have to consider the costs. We learned that there were three broad categories of costs: labor, inputs, and capital. Some of these costs may be easier to conceptualize and understand than others. And I would submit, for example, labor is relatively easy to understand. But even on that point, Professors Smart and Boldway pointed out that even the cost of labor is not predictable because it varies with policy factors such as the cost of housing. They gave a number of examples, and here I'm referring to their report, Exhibit 62, paragraph 82. And you may remember the testimony that about the unpredictability of labor attracting workers to different jurisdictions. So the cost of capital is even more difficult to conceptualize and understand, Justice Hennessy. Of course, we understand that the cost of capital is to include the profit necessary to pay for the risk that the investors take. And it is difficult to measure risk. Risk itself is a concept that we heard about from the various different experts. And we address the risk complications in our written submissions at paragraphs 123 to 129. So the investors need to be compensated for the risk that they are taking, the risk that it's not going to turn out to be as lucrative as they'd hoped, but that they won't get back as much money as they might have received in a different investment. So I haven't even gotten into inputs because even the concept of inputs, as I mentioned, other than energy, which is obvious, is a little bit gray as to exactly what is considered an input. But the point being that the normal profit that is part of the capital, it itself depends on competition as well, perfect competition, because we have to assume that the investor is able to determine in a perfectly competitive environment whether their money is better put here or there. So again, the theory of economic rents it's a nice theory, but it's based on perfect competition. The next point is that, and it gets back to your point about the extra penny, keeping somebody in Sudbury or Thunder Bay, for example. So if everybody in the marketplace is actually earning excess profit that my friends say should have been captured by the Crown, if everybody's earning that excess profit, then the excess itself becomes normal, because that is what is required to compensate investors at a rate that they would be compensated if they took their money elsewhere. And this, I point out, is just an example about how theoretical the concept is of excess profit.
Some of these propositions you're making, would they have been better put to witnesses who could have responded?
Well, I'm going to get, it's interesting that you raised that, Justice Hennessy, because I will tell you that Mr. Schachter rightly points out in his written submissions that the defendants did not cross-examine Professor Stiglitz and Mr. Hutchings on the, quote, extremely detailed part of their report dealing with the calculation of their estimates of economic rents. But he also conceded, Mr. Schachter did, in oral argument, that it is, quote, it is all very dense. And Justice Hennessy, frankly, my submission is, it is too dense and too complex for this court to rely on. And don't just take my lawyer's word for it. Our world-renowned professors of economics told us that you can't rely on it. They rejected the economic rents approach as not intended by the language of the judgment. And they explained that there were conceptual difficulties in measuring it, in measuring rents, and in collecting them. And
I'm very troubled by this. I understood that they challenged the theory as unworkable and uncollectible, not the right measure of what should be measured under the judgment. I understand. I don't recall they said we couldn't rely on it. Maybe you want to make that more specific, but
yep,
I
sure.
don't know that it was boldly called unreliable evidence.
Oh, okay, I will get to that. So the examples that, first of all, clearly Minson and O'Riordan did say that it assumes perfect competition, which doesn't exist in the real market. And the concept oversimplifies what's really going on. The example that Professor Mintz and Mr. O'Riordan gave was some part of that excess profit is not attributable to the so-called value of the raw or unprocessed resource, but rather it's attributable to the managerial skill in its extraction or to specialized knowledge or technology required for its extraction. And here I'm referring to their slides, Exhibit 31, Slide 38. And Professor Minson or Mr. O'Riordan spoke about the transfer pricing problem, which Professor Smart and Bodway also raised. There's two parts to the transfer pricing problem that they explained for us. In some cases, when a producer extracts and processes the resource, the final product, the final price, will represent both the raw material and the processing. And how do you accurately parse out what is the value of the raw material versus the value of the processing? This is how I understood their evidence on transfer pricing. That it's not possible to accurately measure the excess profit or the resource rent because you can't parse out which part really relates to the raw unprocessed resource versus which parts actually relate to other things like the processing itself. And it's particularly difficult to be able to parse those things out when the same producer is doing both parts of the puzzle. Because remember, and we'll get to this, how do Professor Stiglitz and Mr. Hutchings determine what are resource rents? Well, they use, when we'll get to this, proxies and hypotheticals and assumptions and extrapolations. But they're based on evidence that's reported in, public sources like StatsCan about cost of labor, for example. But Professor Smart and Bodway pointed out to us that quite often this kind of information, reliable information, is not available because private producers won't necessarily share their information about exactly what their costs are. They may not be obliged to share it if they're not public companies. And this sort of, I think, overlaps with or helps explain the transfer pricing problem. We don't have perfect information. Now, the second part of the transfer pricing problem is actually a problem in collection. That has to do with the fact that a manufacturer may process something in a different jurisdiction in order to take advantage of a lower tax rate. But just trying to stick with the problems in measurement. So I gave you the example of, we don't know which parts of that excess profit is actually attributable to the resource itself versus what might be attributable to other things not captured in the typical categories of labor inputs and capital, such as, for example, managerial skill or technology. Where does that fit? Another problem I mentioned is that the difficulty in measuring these things. So Professor Stiglitz and Mr. Hutchings have a way to answer all of these problems and to estimate the economic rents. So how do they do this? Well, they explain it in the appendices to their reports. And my friends took us to, in particular, pages 115 to 124 of the Hutchings and Stiglitz joint report. This was the part where my friend, Mr. Schachter, conceded that it is all very dense. And I thought, I'm going to go through that and understand it so that I can explain it to the court. And this is what I understand. My colleague will put it on the screen so you can follow along. Pages 115 to 124. You see the process that they're following. The purpose is to calculate the economic rents arising from the minerals extracted from the treaty territory, using as a proxy excess profits for extractive firms, which means we will not capture rents collected, for instance, by labor or other firms in the form of higher than competitive wages or input prices. How do we really know what are the higher than competitive wages, for one thing? Well, that's okay. Professor Stiglitz and Mr. Hutchings can explain that. They give us a formula, and they go on in these pages to say, how do they do this? They use proxies and estimates. They use available historical financial data from StatsCan, for example. They refer to StatsCan. They make assumptions, and they extrapolate. And as much as I would like to, Justice Hennessy, explain this to you, quite frankly, I cannot. And this is where I'm getting to my point. It's too complex to rely on. And that's not just my own shortcoming, Justice Hennessy, because I'm backed up by 4 economists, 3 of them doctorates, who tell us that it's a theoretical construct. And again, the problems are, it's problematic. Professor Mintz and Mr. O'Riordan make the point, it's problematic to use historical data, as Professor Stiglitz and Mr. Hutchings do, since there is little of it available the further back you go. If you're going to try and estimate, as Mr. Hutchings tries to do, what was the cost of labor back in Thunder Bay, back in 1876, there isn't much historical data to provide us with reliable figures. This is the point that Professor Mintz and Mr. O'Riordan make in their report, Exhibit 29, paragraph 98.
Is that a feature of it's too complex to rely on? Or is that a different criticism?
Remember, the reason it's too complex, it's too simplistic for me to say it's too complex to rely on, because I'm also telling you that this case is worth the complexity that to truly understand it. So I don't want to be too glib in saying it's just too complex. I shouldn't really have phrased it that way. What I mean to say is our experts tell us that it's imperfect because it is so difficult to measure accurately and to collect, which is a different point we'll get to, but it's the measurement problem. And the complexity is in the fact that in order to measure it, you have to make so many assumptions. And these assumptions are are complex and difficult to understand.
I'm glad you sort of cycled back on that, because I was going to say, if there is a case that is worth the complexity, surely it is this one. And I think of, for instance, copyright infringement cases, or I don't know, an Apotex case. Surely those are spectacularly difficult to understand. And that's our job.
Yes.
To do our best. And if if something by its nature is too complex or too dense, our job, whether as litigators or as the court, is to take the time and do the work to understand it. That's how I think of it. And as I hope is very clear, I don't come to this with a background in economics, but the court cannot throw up its hands and say, oops, way too complicated for me. So I hope you're not telling me to do that.
I understand that point, Justice Hennessy, and I do acknowledge, and in fact, I've made the point earlier and I'll make it again, with respect to the present value assessment. The criticism that the Booth-Kersner approach, for example, is too complex, I don't think lands any weight, because it's a complex case. And the same argument would go here as well. I do understand that. You can't just throw it out because it's complex, absolutely. But what I'm really getting at is, it's not so much the complexity, it's the unreliability of it as a theoretical concept. And here we have expert economists backing us up with evidence to say that that's the case. I gave you some examples. I wanted to give you some references to their reports, which I didn't finish doing. So let me just tell you, for example, the problem about using historical data, that the lack of accurate historical data on which to make assumptions and projections for what the cost of labor would have been, or what the competitive cost return on capital would have been. The lack of historical data is mentioned in the Mintz-O'Riordan report, Exhibit 29, paragraph 98. Maybe I did tell you that. But there's also the Bodway and Smart report speaks about the problems in accessing information about that would be relevant to rents from private producers. That's at their report, Exhibit 62, paragraph 39. And so two responses I have to your comment, Justice Hennessy, about the complexity. Number one is, I do agree that complexity by itself is not a reason to throw up your hands, as you said. But keeping in mind really what the issue is, it's the unreliability, the fact that you need to rely on these hypothetical assumptions and estimates to arrive at what an estimate of what excess profit would have been. And I do think it's important that we've talked about the importance of realistic results and realism. And this is where I may lose you, Justice Hennessy, but I'm going to make the point that I would submit it is important for the judicial process and for reconciliation that people can actually understand what's going on here. And I take your point about the Apotex case or a commercial bankruptcy that can be incredibly complicated. But those kinds of cases usually involve a discrete number of companies. And this case is significant for all of Canada. And I think that it's important that the case is based on a foundation that people can actually understand. And as I said, I understand that I may not win you over with that argument, but I wanted to make it.
I think it is a significant point. But I keep going back to this. Isn't that our job at the end of the day to make it understandable? Possibly mine, but you have, I mean, what I have been saying throughout this trial, you, counsel and witnesses, have to get me there.
Yes.
So if that's a direction for how I must write or decide, that's one thing. But the question I have is, if you say it's unreliable because it's based on hypothetical assumptions and estimates, isn't that what cross-examination is for? Challenge the hypotheticals, challenge the estimates, and I mean, that's the usual process with every expert, because an opinion is based on usually something more than just the facts. It's based on estimates and hypotheticals. So if, to me, the challenge to that evidence is not that the economic rents theory is not that it is too complex or too complicated, or that it is based on certain or many hypotheticals or many estimates, but that there are problems with those estimates or hypotheticals. And I can also say that for me, and I tried to ask questions of Crown economists to show where I was, where and when I was having a problem understanding the evidence, and maybe you can help me as well, that collectability is not the issue. As I understood it, the plaintiffs aren't saying that the Crown must collect the rents. As I understand it, the theory is based on this is a measure of value. And so, and then they go from there. But I'll leave that with you.
Thank you. There's a lot to respond to there. I think 2 points in particular that I'd like to make. I take it that Justice Hennessy, you were dissatisfied with the cross-examination of the plaintiff's expert witnesses.
I wasn't dissatisfied. I'm just saying it brought us to where we were.
Yes.
Or where we are. I don't say I'm dissatisfied with it. But if today you say you can't rely on those hypotheticals, I say, point to me in the evidence where you get there.
Yes, and the best evidence I can point you to, Justice Hennessy, is the responsive reports filed by the experts for Canada and Ontario. Because I think those reports, if you read them thoroughly and carefully, they do respond to all of the arguments made by Professor Stiglitz and Hutchings. And frankly, I think they do it in a clearer and more understandable way than I could have elicited through cross-examination. So don't forget you have those responsive reports, reply reports by those experts. The other part of your question that I would address is your question about, are the plaintiffs really saying that the Crown should have collected 100% of the resource rents? And collection is another issue we're going to get to shortly. But your point being that perhaps that's not really what the plaintiffs are looking for. They're not looking for the Crown to have collected 100% of resource rents. They're just looking for the Crown to have shared 100% of resource rents on the basis that this was the value of what the Anishinaabe brought to the table. That's the language, the way that it was used. And here is where it's important to go back to the actual treaty promise. And that's where I submitted on the first day. The treaty promise is is not it's set out in that way. It's that the Crown promises and agrees that in case the territory hereby ceded shall at any future period produce an amount which will enable the government, without incurring loss, to increase the annuity, then and in that case, the same shall be augmented from time to time. The treaty refers specifically to the territory producing an amount. So the measure here, Justice Hennessy, is not the value of the resources in the territory. And we looked at the way the Court of Appeal addressed it and the fact that they explicitly removed the phrase, the value of the resources, from the original stage 1 judgment. Because what we're focusing on, the language of the treaty tells us, we're focusing on amounts that were actually produced. And furthermore, as I began my submissions today, this was something the parties agreed upon. The judgment makes that clear. The parties agreed that we're looking at revenues of the Crown. Revenues of the Crown. That doesn't include resource rents that the Crown did not collect, that may have gone to third parties. And again, the third party point is explicitly made by Justice Horrigan in the Court of Appeal. The Crown is not expected to have conducted its affairs and policies so as to ensure it was not benefiting third parties other than the treaty beneficiaries. So I'd like to turn to just some of the collection problems, which some of them we might have already discussed. I was going to say, if you are confident that the theory of economic rents actually makes sense and that economic rents can be adequately estimated, then you still have to consider whether they can be collected. And this is where we get into problems of capture. And here I think it's helpful to make sure everybody is on the same page about what is meant by taxation. Because to my mind, it seemed to me during testimony, there was some confusion about what was meant by taxation. And I just want to make sure that the court understands it's imprecise and inaccurate to separate these kinds of revenues into two types, the direct levies versus the indirect taxes. We need to remember that the experts spoke of even the direct levies as, in many cases, a form of taxation. So taxation really includes both. Obviously, taxation is a method by which the Crown collects money from individuals and companies. We've heard that the Crown collects rents indirectly through taxes. Mr. Schachter suggested that was 30%, and I'm going to deal with the 30%. But it's not right to conceive of taxation as only collecting as only collecting rents indirectly. Some taxes collect rents directly. So I just wanted to point out the evidence from both Professor Stiglitz and Mr. Hutchings and Professor Smart and Bodway, where they, just in case you want to go back to it and understand this point, first we'll start with Professor Stiglitz and Mr. Hutchings. Their report, Exhibit 3, paragraph 69, they describe it this way. They say the Crown chose to collect some portion of the rents through more direct taxes, charges, fees, and prices, like the mining profit tax, the stumpage fee, and water rental charges. So I'm just trying to emphasize that in case, and I could be wrong, but in case Your Honor was under the impression that taxes were different from resource revenues, I'm going to show you that in fact, there's no clear line between them. And this may become relevant, and I suggest it is relevant when we look at Mr. Schachter's argument about the 30%. But just also to emphasize, I'll ask my colleague to put on the screen a table from Professor Smart and Bodway's report. This is Exhibit 60, Table 1, at page 25, where they set out the categories of net Crown resource revenues they considered. And you'll see that that includes mining profit tax, mining acreage tax, and further down, fire taxes or tax, I can't read it. Just to the point again that, so there's no misunderstanding, taxes is a way generally that the Crown collects revenues, and you can't really separate them into two neat categories.
That tax is understood largely or broadly is the way the Crown collects revenues.
That's correct. Now, I know if there are any tax lawyers from the Department of Justice watching the proceedings, I'll be getting into some trouble because I'm sure it's far more complicated than that. But I do think for our purposes, it's sufficient to say that taxes generally is a method by which the Crown collects revenues. Now, so how are rents captured? Some of the rent is collected by the Crown through direct levies, royalty fees, stumpage fees, and some kinds of direct taxes. We just saw that from Professor Stiglitz and Hutchings. Maximizing rent collection would require collecting all of the rent, which would require taxing it at 100%. And here I have to get back to the point you made where you said that's not what the plaintiffs.
Very sorry. What's being set up there
Yes.
is printing out mysteriously on my computer. So I'm wondering if we have an issue.
It is or is not.
It is. Oh, okay. I think I hit it wrong button.
Maybe tell me where that button is.
What was the, what, you said what's being said is being printed on your computer, isn't that the point?
I think
It's the Department of Justice tax lawyers that are watching me.
Don't let him see that again, Mr. Rankin.
So. So I had been saying that maximizing rent collection would require taxing all rents at 100%. And here I wanted to again acknowledge the point you've made, Justice Hennessy, that that's not, as you understand it, what the plaintiffs are actually asking for. Again, they're just asking for the court to understand the value of what the Anishinaabe brought to the table. And you have my answer on that. That's not what the treaty actually requires. Not to mention, we also address this in our written submissions to some degree, when we point out that there were, of course, other benefits to the treaty besides just the augmentation clause. So we need to keep in mind as well, those other benefits that we discuss in our written submissions. The fact that the treaty promise was not to pay out in annuities a value commensurate with what was with the value of the land does not, it's not required because there are other parts of the treaty that were of value besides the rents that might have been collected from resources.
I'm missing that point.
But the point is, and I wonder if, not pulling up my written submissions, but I think it's articulated well there. But the point being that the treaty promise was, as I read, in case the territory ceded shall at any future period produce an amount which will enable the government to increase the annuities. This is not a promise that the government is going to pay a share of resource revenues that reflect the value of the resources in the treaty territory. What was exchanged here was a promise that annuities would be increased if the territory produced revenues. But there were other things as well that the Crown exchanged with the Anishinaabe for the territory. Promises such as spelled out in the territory, hunting and fishing rights, insurances that money that, and I really shouldn't be going from memory, I should actually be looking at the treaty. Just maybe give me a minute, I'll find our written submissions where I think we deal with this. The treaty reflected, and here I'm reading from paragraph 10 of our reply. In response to my friend's argument about the importance of reciprocity and the idea that the Crown should have come to the table with something of commensurate value as to what the First Nations brought. And there's this suggestion in this case, Justice Hennessy, that in order to bring something of commensurate value, the Crown must pay some portion of the resource rents. And the point I'm making is the common intention of the parties was to share in a way that would provide for both communities. At the time of the treaty, the First Nations were experiencing a number of social and economic difficulties, such as the scarcity of animals used in the fur trade and the illegal invasion and occupation of their lands by miners, issues which the First Nations believed the Crown could help them with. The treaty reflected the Crown's intention to comprehensively address these issues and its own obligations. The other provisions of the treaty demonstrate that more than a promise for an annuity was exchanged. Protection for hunting and fishing rights, reservations, conditions for the sale of reserve land, the forfeiture of proceeds of sales from any reserve land before the date of the agreement, and financial compensation. So with that introduction, I just briefly refer to a few parts of evidence as to the problems in trying to collect rents at 100%. We've already talked about the difficulty, first of all, in measuring what 100% would be. The problem that there's a lack of data from private producers to truly understand their costs. And the problem that the rent may actually be attributable not to the resource itself, but to other factors. And you may recall the evidence of Professors Smart and Bodway and Mintz that companies and people try to avoid or evade taxation. And Mr. O'Riordan's point that high tax rates can discourage production. Mr. O'Riordan testified that if tax rates had been higher in order to try to capture more of the resource rents, the pace of resource development may have been lower. And that one of the implications of that is that the historical data that Professor Stiglitz and Mr. Hutchings used to estimate the resource rents might not be appropriate to use. That data would not be appropriate to use if in fact tax rates had been set higher. And that was made at Exhibit 34, the slide deck of Mr. O'Riordan, Exhibit 34, slide 13. And of course, the point being with respect to collection, and this point actually, I think, without even hearing the evidence the Court of Appeal made, the Crown may have other non-revenue generating objectives. In summary, on this problem point, I want to refer to the statement of Professors Smart and Bodway in their report, Exhibit 62, paragraph 53, where they say, because of these conceptual and practical difficulties, both in measurement and collection, rent taxation remains a theoretical concept employed by economists, which has rarely and only recently been, and still rarely is, applied in real world tax systems. So if we want to take a look at the non-breach world and consider realistically and reasonably what would have happened in a non-breach world, realistically, resource rents would not have been captured and shared with the First Nations. We know this because the Crown does not collect resource rents. What would have happened is a sharing of net Crown resource revenues. I'd like to then,
Just two questions on this. One of the significant parts of the theory, as I understand it, the theory that is then demonstrated by a calculation of what the resource rents are, is for the purpose of calculating the indirectly captured revenues, those captured through tax. And I'll ask you to direct me or help me recall if I misrecall that. I don't recall there was a grave challenge to the assertion that one can look at resource rents to make some estimate, not necessarily precise, of what is captured indirectly by the Crown when they engage in the resource extraction business.
Are you thinking of the 30% argument?
Yes?
And that's what I'd like to address next.
Okay.
So we'll move to Mr. Schachter's proposition that the Crown indirectly collects 30% of the otherwise uncollected rents through taxation. I think that's the point you're asking me to address. As I understand it, Mr. Schachter suggests that the Crown should share all of the resource rents, including those not collected by the Crown. That would be the $126 billion figure on the 60/40 present value assessment. Or failing that, sharing all of the resource rents, would be sharing not just the net Crown resource revenues, the directly captured portion of the rents, but also 30% of the uncollected rent. And he estimates this figure, again, brought forward at 60/40, to be 77 billion. That's what we're talking about. So where does this evidence come from? I think it's important to look at the evidence to find out where it comes from. And the place to start is actually in the plaintiff's compendium, which I hope you still have with you. It's Exhibit II.
I do not have it here.
I'm going to have to get my copy too.
And I'm wondering, I'm just looking at the transcript, 1458. 30 is where you say, so I understand it, Mr. Schachter suggests that the Crown should share all of the rents, which would be 126 billion, based on 60/40 present value, or failing that, sharing all of the rents.
All of the NCRR
Oh,
being, I'm sorry if I misspoke there.
okay, it now makes sense.
All of the NCRR being
Being directly
captured
plus 30% of the
of the indirect capture. Yes, sorry if I
Thank you.
misspoke.
Just to correct it, 30% of the indirectly captured is what you just said. Now, the monitor says 30% of uncollected. Right.
Yes.
You said it, no, you said it
No.
correctly a moment ago. The monitor originally had it something different.
I understand, and I don't have the monitor in front of me, so I'm sorry I can't go back to make corrections, but maybe I could just,
Here you go. It will highlight it.
I think this reflects what I intended to say.
Okay, maybe you can give it to me again.
Yeah. That my understanding is Mr. Schachter, first of all, would want a share of the $126 billion figure, which is all of the rents, collected and uncollected.
All right, and then you said
Okay.
failing that.
Failing that, my understanding is that he's suggesting the NCRR, which I've described as, first of all, not just the NCRR, which is the directly captured portion of the rents, but also a portion of the uncollected rent. And my understanding is Mr. Schachter suggested he wants 30% of that uncollected portion because he says that that 30% actually was collected indirectly through taxation. And it may be the way that I've characterized it as uncollected, and yet at the same time acknowledging the argument that, well, no, it's not actually uncollected. It is collected just indirectly through taxes.
Or some of it is collected.
Yes, and the figure
30%.
that Mr. Schachter uses is 30%. I view it as is the rents comprise the resource revenues that the Crown actually captures directly through net Crown resource revenues, direct taxes, levies, right? Then there's the otherwise uncollected portion that my friend argues it's not uncollected. 30% of it is collected indirectly through taxes. That's how I meant to describe it, and I think that's accurate. So where does this evidence about 30% come from? The place to start is in the expert report, the expert reply report, actually, no, it's an exhibit II, the compendium of my friend. I'm looking particularly at pages 77 and 78. And these are pages from Mr. Hutchings' reply report. This is behind tab 11 of my friend's compendium. I hope you have it. Or if not, it's on the board. Mr. Schachter discussed, there's two graphs, 77 and 78. And you might recall Mr. Schachter discussed these graphs in support of the point that Professors Bodway and Smart included lots of forestry expenses, but only a minuscule amount of forest revenues.
Can I just ask one question?
Yeah.
These graphs 77 and 78, are those pages from the compendium or from Mr. Hutchings' reply report?
These are from Mr. Hutchings' reply report, and they've been reproduced onto the slides.
Reproduced in the compendium?
Yeah, the slides are actually reproduced in the compendium.
Thank you.
And I will find for you, I have a note somewhere about the exact pages it comes from. I'm going to say, I'm going to say that it's Exhibit 10, paragraph 65. Could my friend look at Exhibit 10 to see if this is where these, I believe it is Exhibit 10, which is a reply report of Mr. Hutchings. If you'll just give me a moment, I'll take a look at.
In the meantime, could you tell me what pages they're reproduced in the compendium?
Yes, at pages 77 and 78.
Oh, those are pages 77 and 78. Okay.
Oh, you know where we're going to find it? Is in Mr. Schachter's index. Right. Thank you very much. Yeah, you know, my friend, Ms. Lewis, has indicated it shows that this is from a demonstrative. It's obviously slide 117 from the demonstrative, but it actually is lifted from Mr. Hutchings' reply report. And I believe that's report Exhibit 10. Page 37, 34. So I'm right, it's Exhibit 10, and I'm sorry I don't have it in front of me. We talked before about the problem with the volume of documents here and the time it would take me to look it up on the computer. My note says that it's from the reply report, which was Exhibit 10. So these graphs were taken from Mr. Hutchings' reply report, Exhibit 10.
Slide 30.
Put into his demonstratives and then put into my friend's compendium
At
pages 77 and 78.
Thank you.
Okay, I'm sorry about that. They're not providing a clear path. But so when Mr. Schachter described this, he explained to us what's happening here is in replies, Mr. Hutchings' reply report. He's replying to what he sees as Professor Smart and Bodway's improper calculation on forestry expenses. He says that Professors Bodway and Smart included lots of forestry expenses, but only a minuscule amount of forest revenues. And that forest revenues would actually be much, much greater if you were to count the gross domestic product of paper manufacturing, wood product manufacturing, support activities. You see those things on the right side of the graph. So the point that Mr. Hutchings is making in his reply was that, sure, Bodway and Smart's, if you don't mind, I'll call them that. Bodway and Smart's estimate of expenses for forestry looks really high, but the truth is they're not really including all the relevant revenues. And when you look at the context of the broad GDP of the forestry industry, you see that the expenses are actually small. This was the point he was trying to make. So to illustrate this point, on the very next page, you see the next graph where he says he's going to estimate what are Crown revenues through all channels of the forest sector. Because the first graph he shows us,
He being Mr. Hutchings?
Mr. Hutchings, sorry about that.
Oh, okay, no problem.
Mr. Hutchings says, look, there's actually all kinds of extra revenues here that really express the gross domestic product from forest-related industries. And he says, really, the revenues we're talking about here aren't the small amount of forestry revenues that Bodway and Smart say are direct forest revenues. Hutchings here is saying, really, you got to think about the entire GDP created by the forest industry. And looked at it that way, in fact, the revenues are, well, he says, an OECD study, Organization for the Economic Cooperation and Development, says, generally speaking, that governments generally capture about 30% of GDP through taxes. So we'll just estimate that the revenue from the entire gross domestic product produced by the forest industry, we're going to estimate that as 30%. And that's the basis on which he makes the graph on page 78 of the compendium.
I thought the
So-
purpose of that graph, I'm doing my best to recollect that one of the significant points that Mr. Hutchings was trying to make was there was a matching problem.
Yes,
That if you take a narrow view if you take a broad view of expenses and measure it against a narrow view of revenues, you're going to have invalid evidence. And I thought what he was trying to do, among other things, was say, if you want to look at all those expenses, look at all the revenues. Wasn't that the purpose of that?
yes, you're right, Justice Hennessy, that's exactly right.
Okay, but
So
but you're saying, among other things, that number comes from a single OECD report that talks about government tax collection on GDP.
you're anticipating my argument. I'm getting there. I wanted to situate, where does this 30% come from? Because it wasn't in the expert reports filed by Stiglitz and Hutchings. It wasn't in the reports until the reply, and it was brought up in this context. And I'm going to explain to you, Justice Hennessy, why I think this context is important. In my submission, Professor Stiglitz and Hutchings aren't telling you that the fair way of calculating what should be shared with the Anishinaabe is to consider that 30% of the, what I've called the otherwise uncollected rent, was in fact collected through indirect taxes and needs to be shared as well. That's Mr. Schachter's argument. That's a point of advocacy. We didn't actually hear that from the experts, is my submission. So I want to show you, where does this idea of 30% come from? And I want to demonstrate to you it arose in this context. It was introduced by Mr. Hutchings for the first and only time in his reply report in the context of this argument he was making about the forestry sector. And the evidence he relied on for this, I think it was actually 33% of GDP, comes from he footnoted it too, and I actually do want to pull up the actual report. He footnoted it to an OECD study. I apologize for the delay as I pull this up on my computer. And at the same time, I'd ask oh, this is perfect. I'm just gonna ask my colleague to pull it up, and she's already done so. So we're looking at, this is Exhibit 10, Mr. Hutchings' reply report, paragraph 65. We can use these measures of economic activity. Again, he's talking about the forestry industry in response to Smart and Boatway, to provide an estimate of total Crown revenues from all streams from the industries the Crown considers to be the forest sector. Data from the OECD provide estimates of all tax revenues as a percent of GDP by country and year. And he goes on to say Canada averaged 33% during the period covered by the above data. So figure 3 below, and this is the figure we've just been looking at. If my colleague can scroll along, you'll see. Here we go. That's the figure we were just looking at, or close to it anyway. So this is
So the green line is
30% of the entire GDP in the forest-related sector.
But can you go back to paragraph 65, please? Is the green line Smart and Boatways?
No. It's Stiglitz and Hutchings, Mr. Hutchings in particular. It's Mr. Hutchings. Figure 3.
Last sentence says figure 3 shows estimated Crown revenues. Oh, along with Boatway and Smart's included revenue.
Right. And so the distinction that you're seeing here is the green line is Mr. Hutchings' estimate of total Crown revenues from the forestry sector based on a rough calculation of 33% of all GDP in the forestry sector. And he's comparing that with the orange line being the revenues that were included by Smart and Boatway. But again, my point here is not to get into the argument about which were the right revenues and expenses to include. The point is to show where this concept of 30% capture comes in. And in fact, Mr. Hutchings uses the percentage 33%, but my friend has conceded on average 30%. But where does that come from? It comes from an OECD study. And so I'll ask my colleague to bring up that study, which is part of the joint book of documents. And it's tab 1389. Is this OECD study. And while we're waiting, oh, I see it's pulled up. I was just going to emphasize that, remember, in the reply report, Mr. Hutchings is saying for the time period of this graph, which is 1997 to 2018, when you look at the graph, that's the time period he's talking about. He went to an OECD website, you can see, and he plugged in a time period in a country and came up with that result. But you'll see from that page that's being produced as part of his report and exchanged in the joint book, that the OECD describes tax revenue here. Tax revenue is defined as the revenues collected from taxes on income and profits, social security contributions, taxes levied on goods and services, payroll tax, taxes on the ownership and transfer of property, and other taxes. So again, we're talking about tax on gross domestic product, not on resources specifically. And we're talking about a wide range of types of taxes. So this, I think we can assume, includes that it would include, for example, the income tax a carpenter who works in a furniture manufacturing facility would pay. That would be an example, I submit, it would seem, of an indirect tax from the forestry that can be related to the forestry the GDP contributed by the forestry sector. But Professor Smart and Bodway told us that that type of tax on income is not properly conceptualized as a tax on the resource. That's a tax on labor. So
they took an example from that OECD definition and said some of these taxes are not properly a tax on resources. I have that right?
yes, I think you do have that right. Smart and Bodway said some of these taxes are not taxes on resources, but I think it's also obvious from the OECD description. They're not just talking about resource taxes, they're talking about social security contributions. And they're not just talking about taxing resources, they're talking about taxing the entire gross domestic product of the country. And they're not just talking about taxing the forestry sector, although that's the context in which Mr. Hutchings used the figure. The figure relates to the entire gross domestic product of the country. So before I explain why this 30% is unreliable, I do want to emphasize, I was going to get into where in the evidence do we find this? And the first point is, the first time we find it is Mr. Hutchings using it in this context, where he's trying to explain why Smart and Bodway were, I'll say, stingy on their revenue inclusion. But it is picked up, it's also mentioned by Professor Stiglitz in two parts of his evidence, in oral evidence. And these are the same parts that my friend Mr. Schachter cites in his written submissions on where the evidence lies to support his assertion that the Crown actually indirectly captures 30% of the rents. And remember, we're talking about resource rents, right? The point here is capture of resource rents. And Mr. Schachter says we can assume that the Crown captures 30% of the resource rents because, generally speaking, the Crown captures 30%. So we do see this. I looked at where does Mr. Schachter find this evidence. He also refers to the testimony of Professor Stiglitz at pages 466. And we'll start there. Excuse me for a moment. Oh, I made a mistake. It's 446. Thank you. I'm sorry? Okay. The reporter advises that she needs a break. And I must say, Justice Hennessy, I'm concerned about timing. And so I've been trying to
and we'll talk
discuss off the record, perhaps the timing issue.
off the record, on the record, but let's just move to that
Thanks.
for a moment.
Off the record, so the reporter doesn't have
Off the
to.
record. How are we doing on timing?
I had
Actually, perhaps, well, you tell me this. So there's two different things. Where are you and
Yeah.
what was the original plan?
right. The original.
This court is resumed. Please be seated.
Justice Hennessy, I wanted to finish what I started on explaining where this concept of 30% indirect capture comes from, so that I can then explain why you should not rely on it as part of the award of compensation. So we were looking at where does it arise in the evidence And I showed you that it comes from Mr. Hutchings' reply report, and it was raised in the context of dealing with the forestry sector. But it was also mentioned by Professor Stiglitz 2 times in his oral testimony. The first part is at page 446 of the transcript, and I'm going to read from it, but it's not that long. So is it a fair thing to say that all revenues that come from land essentially come from the rent? Is that, can you say that? Answer, basically that's what we're saying here. Rent is the value of the land, including resources. And what we're trying to do, what we're trying now to do is talk about tracing where that's gone. And it doesn't disappear, it just goes somewhere. The scarcity value of that goes somewhere into the economy. And the other idea that I want to get across is the government recaptures a lot of that. Question, aside from saying a lot of that, is there any way to sort of help with what a lot means? Well, we know from general studies like, and again, an OECD study says that the government today recaptures, the average tax rate is somewhere between 25 and 35%. And I can't quite recall what number. Question of what? Of GDP? Answer, of GDP. I'm sorry, 25 to 35%. And it goes on. Then the next time it appears in the evidence is again in the transcript of Professor Stiglitz at page 530. And here we're talking about an extreme effect where the Crown could decide not to collect any rent directly at all and just collect everything indirectly. And Professor Stiglitz tells us, this is an answer that begins on page 529, and on 530 he says, let's say in that hypothetical where they, being the Crown, gave everything away, that is not charged any rents, land is given away, mining licenses are given away, and they still get back roughly 30% in indirect revenues. Because remember, with the income tax and the corporate tax, they recapture about a third. So the government, the Crown, is doing actually not that badly. So that's where it comes from. And my friend, Mr. Schachter, in his,
Sorry, can you tell me who's speaking on page 530?
I'm sorry, it's Professor Stiglitz.
Thank you.
So these are the 2 parts in the oral testimony where Professor Stiglitz refers to this 30% or 25 to 33% or 35%. I believe I'm correct in telling you, Justice Hennessy, it's not discussed by Mr. Hutchings in his evidence, in his oral testimony. And Mr. Schachter did ask some questions about, is it the case that governments capture part of the rent indirectly through income taxes and corporate taxes? He asked that question of some of the Crown's witnesses. I submit that their answers were kind of ambiguous, but Mr. Schachter did make the point to them, and he said in his submissions that generally they agreed that, yes, it's at least possible. I think they said Professor Smart was a bit of a holdout. It's at least possible that some of the rents may have been captured through indirect taxes. But what's important to remember is the government collecting roughly 30% of GDP through taxes doesn't necessarily mean they're capturing rent on resources. They could be capturing, and in fact, in many cases, they are capturing. I think we could use the word rent on other things like labor and capital. They're not actually taxing the resource. So they're not collecting revenue that's attributable to the resource. They're collecting revenue that's attributable to things like labor. So does this evidence support the proposition This evidence being Mr. Hutchings' reply report at paragraph 65, the OECD document, which is effectively just a definition of what they're estimating here, and then these two bits from Professor Stiglitz's evidence. Does this evidence support the proposition that the Crown collects 30% of the resource rents above those captured directly through resource revenue taxes and levies? The answer is no, because first, this 30% is an average of tax collection on all of GDP. It's not specific to the resource sector. Number two, 30% was the average, according to Mr. Hutchings, for 1997 to 2018. There's no evidence as to what it was before then, which is, of course, most of the time frame here. Furthermore, 30% includes all types of taxes, which are very broadly defined in that OECD document we looked at. It includes social security contributions, for example. Corporate taxes that, as I've said, are not taxes on the trees, but taxes on the labor. Now, the other point is 30% includes all tax revenue. How do we know that some of that 30% is not already captured through the direct resource levies that constitute the net Crown resource revenues? In other words, maybe the Crown already has its 30% cut through its mining profit tax or its forage stumpage fee.
Depending on how it's counted.
Yes, and we don't know. There's no evidence about that, Justice Hennessy. So now that I've described this, you may say, well, Ms. Evans, why didn't you cross-examine on this point if you've got these concerns about the 30%? That's because Professor Stiglitz and Mr. Hutchings were not suggesting anywhere in their report or even their reply report or anywhere in their oral testimony that an additional 30% of the difference between total rents, that is total resource rents, and revenues should be a foundation for the award of compensation. As I said before, this is a new issue. It's an interesting issue. It's a new issue raised by Mr. Schachter. And the final point I want to make on it is that we need to be wary of my friend's calculations. So here I want to turn up again the compendium exhibit II. And get back to these charts summarizing the amounts in issue behind tab 4.
II is the plaintiff's compendium.
That's right.
Thank you.
Tab 4 has these charts you might remember. My colleague has one of them up on the board. So at page, first of all, at page 15, Mr. Schachter calculates the difference between the alleged rents and the revenues. And then he assumes that 30% of that difference was captured by the Crown indirectly through taxes. And the figure he shows in column D on page 15 is 763 million. And I can understand that. He's provided his mathematical calculation in the footnote below. What he's done is taken the I did the math and I understood it, and now I didn't write it down. But I do accept this figure, that the difference is the 763 million. So what he's done is calculated the difference between the total rent.
I think it's in billions, isn't it, right?
Well, 0.763
Oh, right.
makes it 763 million.
Thank you.
I think what he's done is he's taken the net, column E, net nominal, direct and indirect, which really I think is, and he subtracted the net, the NCRs. He's come up with 763 million. I don't have a problem with that. That's 30% of the difference. But he takes that figure then, and in the chart on page 18. Oh, here it is. Now I have my calculation written out. Sorry for wasting your time. So the chart on page 18 has it. In the first column, he's got net, nominal, direct, and indirect Crown resource related revenues captured by the Crown. This is his 1.8. And then we know that the nominal NCRR is 1.04. 763 million is 30% of the difference between them. He starts with the rents of 3.9 billion. In any event, he goes on then to extrapolate or bring these figures forward to present value in the next three columns. And he indicates Stiglitz, this is Stiglitz and Hutchings numbers, 14.5, 15.6, 77. And he says, nobody else calculated this. But in fact, Justice Hennessy, nobody calculated it, not Stiglitz and Hutchings. Mr. Schachter's numbers here, when you see the footnotes, he's not referring to evidence. And I cannot figure out how he's done these calculations. I cannot figure it out. And I cannot be at all confident that they are right. And that's on the basis that the experts explained to us, when you bring a historic figure forward to present value, it's a complex calculation that, because of compounding, requires Excel spreadsheets. And every year, you're not applying a specific 7.2% or a specific 5.3%. Every year, we talked about this the first day, you're applying a different percent to a different amount, and it compounds differently. So I'm just saying it's inaccurate to say that these figures are in the evidence. They're not in the evidence. Professor Stiglitz and Mr. Hutchings did not calculate them, and I would be very wary about relying on them.
And you are particularly pointing to page 18.
Page 18. And this idea that nobody else calculated them as though that was a shortcoming. Nobody calculated them because it wasn't an issue. Stiglitz and Hutchings were not proposing that the appropriate measure here was to take 30% of the difference and add that to the net Crown resource revenues. So I'm just about done. I just want to summarize some of what I had already set out on Friday. Ultimately, where does this land Canada for its position on net Crown resource revenues? That's set out in our written submissions. I think I don't need to go to that in detail. Although I will say, now that we've got these documents ahead of us, let's just pull up the chart on page 17, because it illustrates a point that I made on Friday.
Page 17.
Page 17 of that compendium II. So I mentioned to you before that part of the problem, you had asked me, why didn't you, what Canada's done is taken net Crown resource revenues, brought forward at the long-term bond rate, and said the figure's somewhere between these two extremes. And you asked me, why didn't you use the nominal amounts? And I've explained the problem with bringing forward. But why didn't I use other amounts brought forward on different bases. And you can see from this chart, the only figures that for which we can do a direct comparison are the ones brought forward at the long-term bond rate. You can see it plainly in the chart, where you've got the figure calculated by Stiglitz and Hutchings at 8.8, and the figure calculated by Smart Bodway at negative 4.5. None of the other figures have been calculated by the experts, so that's something to keep in mind. The evidence that we have that's directly comparable uses the long-term bond rate. But that's not the reason why Canada is saying the long-term bond rate is the right rate to use. And I'm going to get into what our position is on the present value assessment. But I would say that happily, that the fact that you have these figures in the evidence on the NCRR brought forward at the government bond rate, happily you have these figures because these are the appropriate figures to be considering. I've explained to you why we say NCRR is the right measure. Tomorrow I'll explain to you why we say the long-term bond rate is an appropriate estimate for an assessment of present value. So, not quite done. One important thing to keep in mind is the value of the annuities, present value of the annuities already paid. And happily, all three sets of experts agree. It's 300 million. Now, Booth and Kersner and Smart and Bodway actually say 302. Hutchings kind of rounds it. Let's say 300. He says it's the difference between 8.6 billion and 8.3 billion, which difference would be 300 million. So between 300 and 302 million is the present value of the annuities that were already paid, brought forward at the band trust account rate. And just so you have it, I'm going to tell you where in the evidence you can find those figures. It's in Booth Kersner, Exhibit 38, paragraph 68. It's in Smart Bodway, Exhibit 61, paragraph 83. And it's in Hutchings, Exhibit 8, paragraph 16. Sub C1 and sub D1. And now I really am concluding when I tell you that. Next up is my colleague, Ms. McNamara, who will address spectrum. Keeping in mind, Justice Hennessy, what is at stake when we talk about spectrum? The present value of spectrum-related revenues, which, as I noted earlier, are effectively the same as rents. There's no disagreement. Mr. Hutchings uses the revenue figures as rents. The present value of the spectrum revenues was calculated by Professors Booth and Kersner to be between $58 and $59 million, based on either the Booth-Kersner approach or the BTA. In fact, if you use the Booth-Kersner approach, it's slightly higher than using the BTA approach in these latter years. Because remember, these revenues have only been realized in the last 20 some years. So anyway, what's at stake here is $58 to $59 million in present value. And with that, I'll cede the podium to my colleague, Ms. McNamara.
Good afternoon, Your Honor. Do you need a moment to catch up?
No, thank you.
Okay,
Thank you very much.
no problem. My name is Rhiannon McNamara, and I'm before you today representing the Attorney General of Canada. I will be making Canada's submissions on the issue of spectrum, and I anticipate my submissions will take about half an hour. I'm cognizant of the time, so I don't want to end up speeding up too much just to get it in today. But hopefully we'll be able to get through at least the majority. You can find our written submissions on this issue at paragraph 147 of our written submissions. And in some, it is our submission that revenues from radio frequency spectrum are not relevant for the purpose of calculating share for two reasons. The first is that the value associated with a spectrum license is tied to the customer base, not the land. And the second is that unique properties of spectrum distinguish the collected revenues from the revenues generated by the other resources in this case. To give you a bit of a roadmap, we're going to look at three topics. First, we're going to quickly look at the judgment and some of the wisdom from the stage 1 decision. Second, I'm going to bring you back to some basics and talk about what spectrum actually is and why it is considered a unique resource. And then lastly, we're going to talk about how spectrum is regulated and how the value of spectrum is related to that regulation. So at this point, I think we're all quite familiar with paragraph 3B of the Court of Appeals judgment. And I want to acknowledge that these are general principles subject to clarification and further direction by the court. But I still think it's worth repeating that relevant revenues were described as those arising directly or in a closely related way to the use, sale, or licensing of land, which could include the waters in the treaty territory. And that includes mineral and lumbering revenues and other analogous revenues received by the Crown both historically and in the future. And the reason why I think that this definition is worth repeating, Your Honor, is because it flows from the reasoning from this court and reasoning that was highlighted by the Court of Appeal. And it's my submission that these reasons demonstrate concern for sharing relevant revenues comes from concerns about the disruption to the First Nations use of the land and their traditions. And there are many places in both the Court of Appeal decision and this court's decision in stage 1 that demonstrate this idea. But for brevity, I will just point you to two of them. And I wasn't planning on bringing them up on the screen, but I will acknowledge the paragraphs in case you wish to take a look. Both paragraphs come from the pre-treaty context. And in both, we see a focus on extraction and resources being taken. So at paragraph 123, we see the Anishinaabe leaders initially voiced objection to unauthorized incursions onto their land and opposed mineral extraction in the absence of compensation for resources taken. And similarly, at paragraph 135, we have reference to Chief Pudishat foreseeing the treaty terms and stipulating the conditions of permission and payment for land and minerals extracted. And I believe these reasons demonstrate historical concern from Anishinaabe leaders about incursions and interference with land and extraction of the resources. And this matters because spectrum and the licensing or use of spectrum does not cause analogous or any interference, disruption, or incursion onto land, nor is anything taken from the land. And so the licensing and use of spectrum does not actually require or lead to control over the land.
My question is, and I don't have it before me, but the future uses of the land reference is where?
Sorry, could you repeat that?
Future uses of the land or future, is that not in the reasons?
I know that the
some
judgment,
reference to
the judgment,
new uses of the land or new production from the land?
absolutely. I know that in the judgment itself, it says revenues received both historically and in the future. And there's no denying that you could discover new uses of resources. But the main point here is that Spectrum doesn't have that kind of relationship to the land. So it's not so much that the parties at the time didn't foresee Spectrum being developed and being used the way it is today. It's that even if they had, it doesn't change that the nature of Spectrum itself and the licenses associated with it, and thus the revenues, are not related to the land.
Well, I accept that that's the argument Canada makes, that the reasons suggest that incursions were such a subject of concern that they in any way limit this court looking at future uses of the land is not a dot I'm connecting. I take it that the word exists there, but I don't see that as key to what the Anishinaabe were concerned about when they were looking at sharing of resources.
Sorry, Your Honor, let me try again. So
They were looking at extraction of resources, exploitation of resources in the absence of compensation, knowing that the land had already been depleted of some of the resources on which they had historically depended. So they had, of course, the Anishinaabe had not engaged in mining yet, but they knew that it was a source of revenue and they wanted a share of the resources that would come from the land should they give up control and administration of the land. But I'll let you continue.
sure, and I actually just want to make a respectful correction that while the Anishinaabe certainly did not participate in mining the way that you would see current mining industries in Canada, that does not mean that the Anishinaabe did not use the minerals that were on the land. And I believe it's Gwyneth Jones' report from stage 1 that discusses their extraction of copper, both for art and for giving it to for trade and similar purposes to that.
And to make material items for themselves.
Exactly. And with regards to this future use of the land bit, what it hinges on for Canada is that future use of Spectrum is not related to the land at all. And when we get further into my submissions to talk about Spectrum's nature, my hope is that it becomes clear that what we're looking at is something, these airwaves, that they don't just exist directly above the land in the space that you and I occupy with our bodies. They exist outward into deep space and into the entire universe. There is no connection between these airwaves and the land, such that with no doubt, future uses of the land are encaptured by the reasonings of this court, but that doesn't lead to future uses of airwaves or any uses of airwaves.
Thank you.
So the next topic that I'm going to talk about here is what Spectrum actually is and why it is considered a unique resource. And it's been a long time since I was in a physics lecture, but I'm going to do my best to bring us back to these fundamentals because I think understanding the nature of Spectrum itself is critical to understanding how Spectrum works, why it's not related to the land, how it is regulated, and its value. And I'm hopeful that that will also help answer some of the questions you may have. So the explanation that's going to follow here comes from evidence that's in the joint book. And those articles were actually introduced by the plaintiff's experts. I'm going to give you the title and tabs for all of the articles now. There's only 4, so it's not too heavy, because unless Your Honor requests, I'm hesitant to have them thrown up on the screen because they're really quick citations and descriptions.
I think the citations will be plenty.
Okay, so the first is Christian Herter's article, and that's titled "The Electromagnetic Spectrum, a Critical Natural Resource." And you can find that in the joint book at tab 1381. The next is Harvey Levin's article, "The Radio Spectrum."
If you're giving a name that we haven't heard, you might have to spell it.
Oh, absolutely. Christian spells with an IAN, Herter, Herter. The next article is Harvey, Harvey, Levin, Levin. And that article is titled "The Radio Spectrum Resource." The first few pages of that article can be found at tab 1383 in the joint book. However, to send you on a bit of a goose hunt, the full article can be found in Exhibit I at tab 9. Exhibit I was Canada's compendium for cross-examination of Mr. Hutchings. The third article is by Patrick, like St. Patrick, Ryan, Ryan, and that article is "Treating the Wireless Spectrum as a Natural Resource." And that is in the joint book at tab 1382. And the final article is by Kathleen Glass and David Rhodes, Rhodes. And that article is titled "Catching the Wave. Should Canada Follow the Global Trend Towards Spectrum Auctions?" And you can find that at tab 1385 of the joint book. Okay, so what is spectrum? Canada does provide a brief overview and description at paragraphs 154 to 157 of our written submissions. And at your most basic level, electromagnetic spectrum is the name for the range of different sizes of energy waves given off by objects across the universe. And these energy waves, even though we can't see them, are all actually light. And we are all most familiar with the part of electromagnetic spectrum that is visible light, what we use every day to see one another. So these invisible waves, as I said, exist in the air and space all around us. And they aren't just on Earth, but they extend into the vastness of deep space, traveling at the speed of light. And those explanations and characteristics can be found in the Herter article on page 652 and the Levin article on page 433. So radio frequency spectrum refers to just a small part of these different sizes of waves. And as I mentioned, visible light waves are also a part of the broader electromagnetic spectrum. And so are things like microwaves and X-rays. So from this point on, when I say spectrum, I'll just be referring specifically to radio waves, to the portion of that range that we care about for this case. And I want to highlight three things about the nature of spectrum that really inform how it is regulated and why its value is the way that it is. And the first is that radio frequency spectrum has no inherent geographic boundaries. The second is that it is instantly renewable. And while it can be polluted, that pollution is distinct from other types of resource pollution. And then the last point is that spectrum is considered common property. And when I talk about common property, I will be responding to my friend Mr. Schachter's discussion of water as subject to common ownership. So the first characteristic there is that spectrum is continuous and is not constrained by some sort of man-made geographic boundary. And I don't think, or natural boundary. And I don't think that this is a controversial point. Mr. Hutchings agreed with this on February 22nd, and you can find that in the transcript if required beginning at page 1747 carrying on to page 1748. So Mr. Hutchings agreed spectrum does not end at some sort of predetermined physical boundary, but rather it is continuous. And none of the other resources in this case display this characteristic. You can't force constraints on spectrum either. You can't bottle it up to transport it elsewhere to be used or sold. And I don't think that that's controversial either. Mr. Hutchings agreed on the same day, so February 22nd, at page 1743, that spectrum cannot be exported. And I want to be completely fair to Mr. Hutchings during this exchange because he correctly noted, well, neither can land. You can't export land either. And I agree. However, this does not make the land and spectrum analogous. And mainly, one way we know this is because land, of course, has geographic boundaries and is not continuous. And there are other differences between spectrum and the other resources too. And that brings us to the next topic, which is pollution. So as we've established spectrum is continuous and everywhere. And in the Levin article at page 437, that's why he describes it as having international character. But spectrum, its usage is considered finite, because based on current technology, there's a limit to how many devices can operate on a given frequency in the same area at the same time. And if too many people are trying to operate on one frequency at once, it will become congested and unusable. And that congestion is what is considered to be pollution. And that pollution is why coordination is required in order for spectrum to be usable. But what makes this kind of pollution so unique is because it is not permanent. Once a broadcast stops, spectrum is instantly renewed and returned to its original form, ready to be used again. The spectrum has not been changed or depleted by that previous use. And you can find those descriptions in the Herder article at page 653 and the Levin article at page 454. And so in this way, spectrum fees are actually rather unlike charges you see on things like toll roads, which in part are generated for the purpose of repairing degradation and maintenance to the physical resource. And I found this explanation from the Patrick Ryan article at page 7, particularly apt. I'm going to paraphrase just to save you all from the long quote, but he writes something like this: spectrum does not disappear like trees in a deforested area. It cannot be exhausted like the contents of a coal mine. Exploitation of spectrum does not have the kinds of negative environmental consequences associated with the clear cutting of a forest, strip mining, or blast fishing near a coral reef. And Herder on page 653 and Levin on page 454 note that it is that part of what makes spectrum so unique is this automatic, costless restoration of spectrum that's not found in any other resource. And why I think it's important to highlight this unique type of pollution is because it actually tells us something about spectrum's nature. It tells us that spectrum and the use of spectrum is separate from the relationship of other natural resources, specifically natural resources that are connected to the land. And what I mean by this, I think, is articulated.
Separate from or different than?
Sorry, I think both.
What are you saying?
That spectrum is both separate from the relationship to the land, and it's also different from that relationship. It doesn't have the kind of interrelations that other natural resources that are related to the land have. And I think powerfully in my memory is the comments from Chief Michano on March 31st about these connections and how actions taken in one area can have impacts on another. We heard how the logging industry caused disruption to wildlife and how logging and mining affect water through rain bringing pollution by runoff, cyanide spills, and aluminum content. And these impacts, this interrelationship, is because the land and all of its resources that exist upon it, including water, are interconnected. But spectrum is not related to this. Its pollution has no impact on other natural resources because it's not part of the land. And I'm just cognizant of the time here. The last characteristic I have in this section to talk about is spectrum as a common property resource before we move into regulation. About 422. So I think I can at least start explaining spectrum as a common property resource, if that's okay with you, Your Honor.
Yeah.
Okay. So the plaintiff's academic articles agree that spectrum is considered a common property resource. You can find this reference in the Levin article at page 433 and the Herder article at 655. And Mr. Hutchings also agreed with this on February 22nd on page 1776 during a discussion that takes place from lines 2 to about 17. And why this common property nature is important, because it directly informs, and in fact, the legislative scheme recognizes that the common property nature of spectrum cannot be subject to individual ownership. And before we get into my friend's submissions, I want to remind the court again that spectrum flows continuously and is not subject to some sort of man-made boundary. So individuals, whether they're neighbors or in different countries, they can affect one another's ability to use spectrum through pollution or congestion. And this is exactly why countries came together and agreed to have international cooperation in order to ensure that spectrum can be used. And you could take a look at the Herder article from pages 657 onward to about 659 for an explanation of the development of the International Telecommunications Union. And this international cooperation element is also discussed by some of the ISED materials in the joint book. One example of this is at tab 0042, where the licensing procedure for spectrum licenses is explained. And from my friend's submissions, I think,
What tab is the
sorry,
material?
tab 0042.
Thank you.
And from my friend's submission, I think they may have agreed that spectrum is considered a common property resource. And I think instead, they just say that that's irrelevant to whether its revenues should be included. Because they submit, you could say the same thing about water, that it has these common property elements, and water is clearly included. And I want to look closely at my friend's comments on water, because originally I had thought water may be a good comparison to spectrum, but it has a number of flaws and quickly falls apart. But this is a rather long section, so I am a little bit worried, I guess in 5 minutes, okay. Do you want me, I could get into some of the basics in the next 5 minutes, or we can wait until tomorrow.
Take your 5 minutes.
Take my 5 minutes,
What
okay.
you can.
So my friends made 2 points here. First, that water is not linked to any land at all. And second, that water is not subject to ownership at common law. And these comments were made on September 13th at page 85 of the unofficial transcript. And they were around lines 11 to 22. And of course, to be fair to my friend, Mr. Schachter, he accepted reserves from this comment to be left for another day. And respectfully, this comparison between spectrum as common property and water as the same is a significant oversimplification of the law relating to water. And before I get into the deep end on water, which I guess I'll do tomorrow, I want to remind the court of how we've already covered that water and spectrum are different. even if you do accept that they're both common property in exactly the same way.
I'm sure the plaintiffs will appreciate that on the one hand, Candace say they're way too complicated, and on the other hand, you say they're way too simple. Sorry, I didn't.
No, that's okay. So the first is that a body of water has geographic boundaries and limits. The second is that water can be extracted. The third is that pollution to the water obviously affects other parts of the environment and vice versa. So contrary to my friend saying water is not linked to land at all, there is clearly an interrelated relationship there. And all uses of water are not instantly renewable. Water can be permanently altered or degraded by use. And water also, we would submit, has inherent value. In addition, it also has important traditional links for the Anishinaabe related to their culture, fishing rights, and travel. And I've already covered that Spectrum does not have these geographic boundaries. You can't extract it. Its pollution is unique because it's not interrelated to other parts or other natural resources. And it's instantly renewable at no cost. The Levin article at page 454 considers this actually to be a basic difference. And so while water,
All of these things.
no, just that it's instantly renewable at no cost. And so while water may not be affixed to the land, as the plaintiffs write at paragraph 480 of their submissions, in the exact same way that maybe a tree or a diamond would be, it's still very closely related to it and affected by the land, while Spectrum is not. And I'm thinking, unless you'd like me to continue, that that's where we should leave off for today.
All right, we'll leave off and I'll just ask a question. Right?
Sure.
There was a time when one needed rivers to travel anywhere in this territory. And that changed. And there was a time when one needed certain things to communicate. Possibly one needed to travel, be face to face, or one needed some kind of technology. But now we use radio waves for that. And it seems to me that identifying those things that make Spectrum unique some of those things that make Spectrum unique are not necessarily those things that take it out of play. Your argument that it is not linked to the land is where you're trying to go. But the fact that it, by its nature, has other significant differences, unless I'm missing some of the dots, I'm not connecting to whether that makes it connected, sufficiently connected to, as you say, the land or the water to be included in the consideration under the treaty. But I'll leave that with you for tomorrow.
Okay. Thanks, Your Honor.
Okay, we'll finish for the day. We'll go off the record.